The model rules require counsel to make reasonable efforts to expedite litigation. Balancing strategic deliberateness and speedy resolution, trial counsel and in-house counsel must determine the appropriate route. Beau Cole of Forman Watkins examines the connection between the reasonableness requirement of ABA Model Rule 3.2, Rule 26, and what delays just won't be permitted. Please welcome Beau Cole.
Good afternoon. Many times, in-house counsel and outside counsel alike are faced with a decision of whether or not to employ a purposeful, strategic delay in litigation. For example, what about the scenario where plaintiff's counsel tells you, look, I've already made too much money this year, and rather than me receiving more money this year, why don't we wait? Why don't we just wait and fund the settlement January 2nd of 2016? Is that unethical? Or what about the scenario where you represent a corporate entity who chooses to wait or is considering waiting until an adverse verdict is received before filing bankruptcy? Do you, as counsel for that corporation, have an ethical obligation to encourage that corporation to move things forward and protect its shareholders? Or what about my personal favorite? I'm sure nobody in this room has experienced this one. What about the situation where you settle on the courthouse steps when nothing at all about the litigation has changed in the last 4 or 5 years? What about that? Is that unethical? Maybe, maybe not. Well, as Joel alluded to a few moments ago, we live in a different day and age now than we did in times past, and we litigate in a different day and age than we did in times past. Now we see corporate counsel constantly in the line of fire. We see each other constantly in the line of fire. So what do we do? What do we do when we are faced with the decision to purposely delay litigation, or when we are subjected to counsel opposite subjecting us to what we consider to be a purposeful delay? Fortunately, in 1983, the American Bar Association attempted to help us solve that problem, help us figure all of that out, if you will. ABA Model Rule 3.2 provides that a lawyer shall make reasonable efforts to expedite litigation consistent with the interests of the client. Simple enough, right? Easy. We just need to make a reasonable effort. Well, I see some of the frowns in the room and furrowed eyebrows and whatnot. Reasonable, what's reasonable? How can we define reasonable? And also, what exactly does consistent with the interests of the client mean? Well, to get there, we have to look around. We have to know where we are to get where we're going. Since the adoption of ABA Model Rule 3.2, 39 states across this great union have accepted it verbatim. Lock, stock, and barrel, they have incorporated it into each individual jurisdiction's model rules. But we've got a few here who have chosen not to, I should say. And of those states, you'll see Nevada, Nebraska, Tennessee, Georgia, Texas, DC, and guess what? You guys, New York, New Jersey, have not accepted the Model Rule 3.2. But the good thing is that all of these states that are highlighted here have accepted at least some version of the Model Rule, which places either an affirmative duty on us lawyers to move cases in, through, and out of the judicial system, or at the very least, a duty not to do anything that prevents the other party from doing that. So let's take a look at those. District of Columbia adds at subsection A, lawyers shall not delay a proceeding when the lawyer knows or when it is obvious that such action would serve solely to harass or maliciously injure another. That's easy, right? Takes a close look at the harm that could be suffered and implores lawyers not to engage in that specific conduct. That's a good one. DC got it right. DC told us what we shouldn't do, made it pretty clear. Georgia took Model Rule 3.2 and added a penalty, which begs the question of whether or not the penalty is severe enough. It says that the maximum penalty for a violation of this rule is a public reprimand. Well, is it severe enough? Maybe, maybe not. All depends on the nature of the litigation and how high the stakes are. If I'm representing one of your companies and if there's a $5 million claim or better, I might seriously consider a risk-benefit analysis as to whether or not a public reprimand would be worth it. Nebraska, on the other hand, says specifically that a lawyer shall not take a suit, assert a position, conduct a defense, delay litigation, et cetera, et cetera. It provides very, very specific parameters and is perhaps one of the best and most succinct versions of Model Rule 3.2. Nevada is perhaps my favorite of all of the states that do not accept 3.2 lock, stock, and barrel, because Nevada seems to provide that a lawyer has full strategic control over every tactical matter, including it provides that a lawyer is not precluded from granting a reasonable request from an opposing counsel or from disagreeing with the client's wishes on administrative and tactical matters. So if there are any Nevada lawyers in the room, you guys have it made. The rest of us, not so much. New Jersey, it adds a provision that at the end of the rule that everybody shall treat each other with courtesy and consideration for all persons involved in the legal process. And of course, everybody in here knows that that happens all day, every day, right? Well, since we're here in New York, let's spend some time talking about New York and New York's version of Model Rule 3.2. New York is somewhat specific in that it focuses on the harm that could be caused, but as you'll see from the star asterisk, whatever you want to call it there, that there is no consideration for client interests, meaning that New York lawyers do not have to specifically consult with or deal with client interests in part of the equation, solving the equation as to whether or not employing a strategically deliberate means of delay is appropriate. Tennessee shares that same thing. Lawyers shall make reasonable efforts to expedite litigation. There's an affirmative duty there, but again, there's no real consideration embodied in the rule itself for client interests. Texas follows Nebraska's rule in that lawyers should not take a position that unreasonably increases the costs or burdens. So we've got some parameters there if in fact we're practicing in Texas. And just for fun, California, Oregon, Virginia, I included them in the slide because they did not adopt the model rules, specifically did not adopt 3.2. So with that being said, I guess we get back to the model rule itself. What is reasonable? And once we get past that threshold question, we have to determine what client interests may justify the use of delaying tactics. Finally, taking it by stations, what other enforcement mechanisms exist? Again, when that plaintiff lawyer calls you and tells you, I've made too much money already, what do we do about that? Well, fortunately, since we're here in New York, we're going to spend the most time talking about New York. Client interests are of no moment. And no state bar association or court can answer every single question under every imaginable scenario, but we sure can learn a lot from the negative perspective. We can learn what not to do. So, if we go back to Model Rule 3.2 to try to give us some guidance as to what is reasonable, the comment as lengthy as it is, provides some guidance. But I caution you about reading the comments and accepting them as they are, because in the scope of the model rules, it tells you in plain English that the comments do not control. They're just a guide. They only provide guidance. But that's all we have, so that's what we use. Looking at the model rule comment, we see that there is a prohibition against lawyers purposely postponing or seeking delay for personal reasons. Okay, so we know that Friday afternoon golf game is probably not going to pass muster under Model Rule 3.2. We also see from this comment that a failure to expedite will not be considered reasonable if it's done simply for the purpose of frustrating an opposing party's attempt to obtain rightful redress or repose. So if I know that I've got a loser of a summary judgment motion hanging out there, and that's going to be a significant value driver, and I just continue to bump it down the road, put it off for whatever reason I can come up with just so that I can delay the inevitable, we know under Model Rule 3.2 that that's probably not acceptable. But the one good thing, which I have in italics here, is that Model Rule 3.2 tells us that the standard by which we should define what is and what is not reasonable is the competent lawyer standard. And what it says is that a competent lawyer acting in good faith would regard a course of action as having some substantial purpose other than delay. So I want you to keep that in the back of your heads, because we'll flesh that out in just a moment. But of the utmost importance is the final sentence of the comment, which states that financial or other benefit from otherwise improper delay is not a legitimate client interest. So again, we're in New York. Let's talk about New York. The text of the rule is there. It says a lawyer shall not use means that have no other purpose other than to delay or prolong. Well, again, there's no affirmative duty to expedite, but there's an affirmative duty present not to slow things down to a screeching halt. The comment is remarkably similar to that in the model rule, in that dilatory practices are prohibited, and the competent lawyer standard comes out again here in the New York rule. So is New York really a departure from Model Rule 3.2 or not? Well, I say it is. Again, there's no affirmative duty to expedite. There's an affirmative duty not to use improper means or tactics. There's no explicit consideration for client interests, and it completely eliminates the model rule's personal reasons exception. So the golf game on Friday afternoon is certainly not going to get you where you need to go. So applying the New York rule, I represent to you all that there is a very, 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 very small amount of case law or professional ethics opinions interpreting Model Rule 3.2, or should I say the New York version of Model Rule 3.2. But there is one, and it's a pretty good one. So looking at this from a hypothetical perspective, if adverse counsel requests copies of publicly available documents to develop a response to a default judgment, and I have those documents, do I have any obligation to provide them to counsel opposite? Well, according to professional ethics opinion number 984, I do not. I don't have to give them anything. Now, is that going to make us friends? Probably not. But the New York State Bar Association says that a lawyer shall not take affirmative steps which result in needless expense, but my mere refusal to cooperate does not render me in breach of its version of Rule 3.2. Now we've made it to Station 2. So how are Rule 3.2 violations brought forward? Well, standalone violations are extremely rare. And the good news for everybody here is that even if you are tagged with violating Rule 3.2, it does not provide an independent basis for liability. Most 3.2 violations are discussed in the context of violations of other statutes or court rules, or in request for sanctions pursuant to Rule 37, or for violations of Rule 16, or for violations of the Big Stick, which is 28 U.S.C. 1927, and Rule 11 sanctions claims. Under 28 U.S.C. 1927, the Big Stick, any attorney who unreasonably or vexatiously multiplies the proceedings may be required to personally satisfy the excess costs. That's a big deal. Under Rule 11, by presenting to the court, you certify as an attorney, as a counselor, that you are not presenting any motion or any filing for the purpose of causing unnecessary delay or needlessly increasing the cost of litigation. Taking a look at Rule 16, Rule 16 encourages early disposition and explicitly discourages wasteful pretrial activities. So what does all of this mean? What do all of these things mean for us as practitioners? What it means is that if, in fact, you find yourself in the corporate crosshairs, as Joe pointed out a moment ago, then there are avenues by which you will be held accountable, over and above just receiving a bar complaint from the recipient of your dilatory tactics, if, in fact, they are not done in good faith under the reasonable lawyer standard. Let's look at a few hypotheticals that are based here in New Jersey, or here in New York or New Jersey. An attorney seeks additional time to respond to a summary judgment motion. Request is granted, but the attorney never files a response. That's a great one. Is that ethical? No. What about setting a status conference, not appearing for it, or leaving before you get called? That's unethical. What about using the legal process essentially to conduct a judicially sanctioned smear campaign to coerce settlement? Is that ethical? No. Especially when you've got 36 other documented instances of questionable behavior. It's probably not a smart thing to do. And let's face it, folks, anytime that you are referred to as engaging in Rambo-style litigation, that can't be good for you. Another quick hypothetical. Attorney refuses to withdraw claims after learning that they're not supported. I'm sure that's never happened to anybody in this room. Is that ethical? No. And in fact, in this particular case, both attorneys were ordered to pretend professionalism CLEs. This is a great case to read. And what about attorneys that are admitted pro hac? What if they engage in dilatory tactics, like interrupting the opponent's answers or initiating inappropriate arguments? Is a violation of 3.2 sufficient to justify revocation of a pro hac? No. But there again, in this case, I would not want to be the lawyer who has to explain to his partners that I have been accused of engaging in litigation as a form of mortal combat. Other quick notes on New York. Discipline or other relief may be imposed if any attorney violates the New York State Rules of Professional Conduct. And for those of you who have a deep commitment to pro bono work, as the Trial Network does, as you saw this morning, if you are appointed as standby counsel, you still have an obligation to make sure that you are not assisting a pro se plaintiff in engaging in dilatory or harassing tactics. So what do we do? What are our practice points? We want to examine the forum states version of Rule 3.2. We want to take a close look and determine whether or not the strategically deliberate means that we intend to employ is reasonable under the competent lawyer standard, has a substantial purpose other than to delay, prolong, or cause needless expense, is clearly separated from your client's pecuniary interests, and of the utmost importance is congruent with any existing court order or rule. You do not want to be on the wrong side of a sanctions motion when you have clearly violated court order. And finally, the last practice point is when you are considering or approving of engaging in what I would consider strategically deliberate tactics, you might want to remind your counsel of the universal directive, which is here. Just don't do that. It's pretty clear from the research that we've put together here within the network that our violations of Rule 3.2 are documented. They're very, very, very well documented. If, in fact, you find yourself on the receiving end of a bar complaint for a violation of Rule 3.2, you can bet that there will be an opinion that follows, which you will have to explain to someone at some point, more than likely your malpractice carrier. Thank you for your time.